And we're live.
Hello and welcome. Thanks for joining us today for Asian Pacific Women Lawyers Alliance and Neighborhood Legal Services of Los Angeles County's programming on renters' rights during COVID-19. I am Valerie Lee, a board member of Asian Pacific Women Lawyers Alliance, also known as APALA, and one of the co-chairs of our pro bono committee. For those of you who are new to our organization, APALA is an organization that promotes inclusion, empowerment, and advancement of Asian Pacific American women in the legal profession. We are devoted to advocating for, educating, mentoring, networking, and developing leadership within the profession and larger community. We also organize events for the community, such as today's webinar on renters' rights. Our presenter today is Jumana Banbat, a staff attorney with Neighborhood Legal Services of Los Angeles County, also known as NLSLA. For those of you who are new to NLS, Neighborhood Legal Services provides free legal assistance to more than 150,000 individuals and families in Los Angeles County and provides a wide range of legal services, including in the areas of housing, immigration, employment law, public benefits, education rights, and disaster assistance. Our presenter today, Jumana, will share her expertise in today's webinar. She will talk about current state, local, and federal laws that impact renters' rights. This presentation will be about 45 minutes. At the end of Jumana's presentation, we will take a couple of general questions before closing out this webinar. By the end of this webinar, we hope that you will be equipped with useful information to share with others. We also have a helpful one-page information sheet provided by Neighborhood Legal Services that summarizes much of this information. If you registered for the webinar, you will already have received a copy of it. If you would like a copy of the info sheet, please email us at apalaevents@gmail.com. That's APAWLA events@gmail.com. And we will send you a copy and a list of resources that you can reach out to for personalized assistance after this program. Thanks again for joining us today. Please enjoy the webinar.
Thank you for that introduction, Valerie. So my name is Jumana Banbat. As Valerie said, I am a staff attorney at Neighborhood Legal Services, and I am presenting today on housing protections during the COVID-19 pandemic. So Valerie gave a great introduction of Neighborhood Legal Services and the kinds of services that we provide. But I do want to share a little bit more about the team that I work on specifically, called the Lawyers Preventing and Ending Homelessness Project, or PEP team. We work specifically with CES partners to provide legal services to remove barriers to housing in an effort to prevent and end homelessness. So these are our services at a glance. So the kind of issues that we address include public benefits, unpaid traffic tickets, expungements, housing, domestic violence, immigration, and unemployment insurance. And the types of clients that we generally assist include those who are homeless, at imminent risk of homelessness, or fleeing or attempting to flee DV, domestic violence, or human trafficking. Our team works specifically with legal issues that create a barrier to housing and can be solved within 6 months to a year. So a caveat before we begin, laws change. So this information is accurate as of the date of this presentation, March 31st, 2021. Because laws and legal procedures change, please check to be sure that the information here is current at the time that you use it. And this is general information, so do not rely on this information regarding your individual specific situation. So an agenda of what we are going to be going over today in this presentation includes a general overview of the eviction process, statewide COVID-19 protections under SB 91, federal COVID-19 protections under the CDC moratorium, local and other tenant protections, and then finally, we'll be looking at some of the common defenses to unlawful detainer actions or evictions. So this is just a brief overview of the eviction process. I'll go through this quickly and then break down some of the bigger steps. So the first step in the eviction process is a notice, an eviction notice. This can be a 3-day, a 15-day, 30, 60, or 90-day notice. After the notice is issued, the next step in the process is the summons and complaint, which is served on the tenant. After the summons and complaint is served, there are kind of two ways that it can go. Either the tenant files an answer or the tenant doesn't file an answer. So if the tenant doesn't file an answer, then a default judgment can be entered, a notice to vacate can be issued, and the tenant can be locked out. And this process does go fairly quickly. If the tenant does file an answer, however, within 1 to 2 weeks, the court will send a notice of trial. And then about 2 weeks later, the trial will be held. The tenant can either win or lose at trial. So if the tenant loses within 5 to 7 days, a notice to vacate will be issued and the tenant will be locked out. And if the tenant wins at trial, the tenant has to pay back rent and can continue to stay on the property. So in an eviction case, the best case scenario for a tenant, if the tenant wins, is that the tenant gets to continue to pay rent and stay on the property. So let's go through some of the steps in a little more depth. So step one is the notice step. The landlord is required to serve the tenant with a notice stating the reason for the eviction and or providing an opportunity to cure. So this notice can be a 3-day notice, a 15-day notice, a 30-day notice, a 60-day notice, or a 90-day notice. This depends on the reason for the eviction and the duration of the tenancy. There are just cause reasons and no fault just cause reasons for an eviction. And I'll discuss what this means a little later in the presentation, but the kind of quick explanation is that there are specifically like enumerated reasons for which a tenant can be evicted. And there are at fault just cause reasons and no fault just cause reasons. So at fault means that the tenant did something wrong, and no fault means that the tenant didn't do anything wrong. Step two is the summons and complaint. If the notice period expires and the tenant does not leave or cure the issues from the notice, the landlord can initiate the eviction in court. So the landlord does this by filing a summons and complaint in court. The complaint states the landlord's case and why they are seeking the eviction. The summons and complaint must be served on the tenant. The next step in the process is the answer. This step is especially important for the tenant because after being served with a summons and complaint, the tenant has 5 court days to submit the answer. It's a very short time frame. And the way that you would calculate 5 court days is you exclude weekends and holidays. So for example, if the landlord were to serve a summons and complaint on a tenant today, 5 court days would be Thursday, Friday, Monday, Tuesday, and Wednesday. The tenant would have to file an answer by Wednesday of next week. So that's 5 court days. The current form is UD 105. That's the form on the right-hand slide, right part of the slide. And there are also attachments for additional defenses. So if you complete the answer through a self-help center or through our office, even though UD 105 is a long form in and of itself, there are additional defenses that you can bring up, and we would include attachments for those additional defenses. The answer is a chance for the tenant to raise the defenses that apply to their case. The type of defenses varies from case to case and is very factually and legally driven. So it really depends on the tenant's very specific situation. The answer is the most important step for tenants. Tenants can lose the case by default if they fail to answer. So if you remember from the previous flow chart, if the tenant doesn't answer, the landlord can initiate the eviction. So the landlord can initiate the eviction in court. 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 The landlord the next step in the process is for the landlord to request and then obtain a default judgment, which just means that because the tenant didn't respond, the landlord wins the case and can proceed with the notice to vacate and the tenant eventually being locked out. So it's very important that the answer gets filed within the 5 court date time period. The next step is trial preparation. So after the answer or at the same time as filing the answer, tenants can engage in discovery. So discovery is a means for obtaining evidence for the case. Because eviction cases are summary proceedings, this means that they occur very quickly. The discovery process has to take place very quickly and within certain timeframes. Tenants can also file a jury demand. The deadline in unlawful detainer cases is generally within 5 days after notice of trial setting. So that also has to be asserted very quickly, otherwise tenants will lose their right to a jury. And then the final step of the process is the trial. So the trial is the opportunity to present the case to the judge or the jury and present any evidence that the tenant may have. So that was a general overview of the eviction process. That was how evictions proceeded pre-COVID-19, and a lot of the protections that I'm going to discuss now affect some of the timelines and the way that evictions move forward right now. But that's kind of a general outline of how an eviction would go. So let's talk specifically about statewide protections for non-payment during COVID-19. Previously, AB 3088, this was also a statewide bill, provided protections for non-payment of rent accrued from March 1st, 2020 through January 31st, 2021. SB 91 extends those same protections through June 30th, 2021. So evictions where non-payment is a cause of action can proceed as of July 1st, 2021. That's after SB 91 expires. A tenant may be evicted for just cause reasons other than non-payment within the protected dates. So we covered it briefly a little early in the presentation, but what exactly are just cause protections? So a landlord can only evict a tenant if they have just cause, meaning the tenant did something wrong, or for no fault just cause, which is also an enumerated reason why a landlord can evict a tenant, but not due to the fault of the tenant. So some examples of just cause include non-payment of rent, committing a nuisance, breach of lease, committing a crime on the property, or refusal to sign a lease if that lease is the same or similar as the previous lease. Some examples of no fault just cause include owner or direct family member moving in, the landlord withdrawing the property from the rental market, the owner complying with a government or a court order to vacate, or the landlord intends to demolish or substantially remodel the property. So let's discuss a little more how the SB 91 non-payment protections work. So there are 2 key time periods to keep in mind for the non-payment protections. The first time period is March 1st, 2020 through August 31st, 2020. So rent for this period can't be the basis of eviction if the tenant timely submits a single declaration of COVID-related financial distress. The second key time period is September 1st, 2020 through June 30th, 2021. So rent for this period of time can't be the basis of eviction if the tenant both submits a signed declaration of COVID-related financial distress for each month and pays a total of 25% of the rent due for the entire period. And paying a lump sum at the end is okay. So you don't need to necessarily pay 25% every single month, so long as you pay 25% of the total amount due for that second time period, September 1st through June 30th. By that June 30th date, that's sufficient to be protected under SB 91. And what's really important is that to get these protections, tenants must give timely declarations. So what counts as COVID-related financial distress? Under what circumstances can you sign that financial distress declaration? COVID-related financial distress includes loss of income caused by COVID-19, increased out-of-pocket expenses directly related to performing essential work during COVID-19, increased expenses directly related to the health impact of COVID-19, childcare responsibilities or responsibilities to care for an elderly, disabled, or sick family member directly related to COVID-19 that limit the ability to earn income, increased costs for the care described above, or other circumstances related to the COVID-19 pandemic that have reduced your income or increased your expenses. So some of the more obvious examples are if you lost your job due to COVID-19, or if your hours were reduced, or if your salary was cut due to COVID-19. But you can also think a little more broadly about COVID-related financial distress. So for example, if you used to take public transportation to pick up groceries, and now because of COVID-19, you have to take an Uber or a Lyft, those are increased expenses due to COVID-19. So the declaration of COVID-related financial distress. Tenants are encouraged to submit the financial hardship declaration on the first of the month or as soon as rent becomes due, if they know they will not be able to pay. At the latest, tenants must submit the declarations within the 15-day notice to pay rent or quit. And that's the 15-day notice that the landlord provides to the tenant. So within that 15-day time period, tenants should submit the declaration at the latest. If possible, tenants should email or text the declaration to their landlords to leave a paper trail. Tenants should also retain a signed copy of the declaration for their own records. And this is an example of what the declaration may look like. The landlord should include a blank copy of the declaration attached to the 15-day notice. There's no kind of standard declaration form, so it could look slightly different, but this is an example of what the declaration may look like. So what if you miss the 15-day deadline and an eviction is filed? So tenants can still file the COVID-19 financial distress declaration within the time to file the unlawful detainer answer. And if you remember, that time is 5 court days. The court will hold a hearing with 5 to 10 days notice. The tenant will need to convince the judge that they had a good reason for failing to submit the declaration to the landlord within the 15 days. An example of a good reason would be a medical emergency. So this is going to be a very factual hearing, and the ultimate decision is up to the judge. So the safest thing to do is to file it, is to provide the landlord with a copy of that signed declaration as soon as possible, at the latest within the 15-day time period. If there is a good reason that the tenant can't provide that declaration, such as a medical emergency, there is still kind of this process for ensuring that tenants are still protected. All right, what are the notice requirements for landlords for non-payment of rent under SB 91? Any notice to pay rent or quit, so this is going to be the notice that the landlord issues. So any notice must provide 15-day notice for any rent owed during March 1st, 2020 through June 30th, 2021. Previously, before COVID-19, it used to be a 3-day notice for non-payment, but under SB 91, the landlord has to give 15 days notice. If the tenant owes money for both covered time periods, so that's March 1st, 2020 through August 31st, 2020, and the second time period is September 1st, 2020 through June 31st, 2021, the landlord has to give separate notices with those blank declarations attached. The landlord has to include a copy of that declaration of COVID-19 related financial distress for the tenant to sign and return. A tenant doesn't need to provide proof of financial distress to the landlord unless the landlord shows that the tenant has income over 130% area median income. And area median income really depends on where you're located, but unless the landlord can show that the tenant is high income, the tenant doesn't need to show that, for example, they lost their job or they suffered a reduction in hours. The tenant doesn't need to provide that proof. Landlords must provide a separate informational notice to all tenants who owe rent between March 1st, 2020 and June 30th, 2021. This notice should have been provided on or before February 28th, 2021. So this notice actually should have already been provided at this point to tenants who had missed a rental payment prior to February 1st. And this is what the 15-day notice to pay or quit may look like. Again, it's not a standard form, so the landlord can provide something that looks slightly different, but this is what a landlord should be providing a tenant if a tenant wasn't able to make rent. So SB 91 also includes a rental relief program. If the landlord and the tenant opt in and agree, 80% of the tenant's debt from April 1st, 2020 to March 31st, 2021 can be paid off. And if the landlord accepts the 80%, the landlord has to forgive the remaining 20% of the debt. So the landlord can't sue the tenant for that additional 20% in debt. If the landlord refuses to participate, the tenant may be eligible to receive 25% of their rental debt. And really the goal of this is so that the tenant can still take advantage of the SB 91 protections, since as we discussed earlier, they do have to pay 25% of the rent owed for that second time period by June 30th, 2021. The application process for LA County opened on March 15th, 2021. The application is available on housing.ca.gov, the Housing is Key website. And the application for LA City actually opened yesterday, March 30th, 2021, and is available at hcidla.lacity.org. I'm going to wait just a few moments before going on to the next slide in case folks want to take down that information. So what protections exist under SB 91 from landlords trying to get around the state law? If a landlord files an eviction against a tenant based on something other than non-payment of rent, the landlord can't collect rental damages that accrued between March 2020 through June 30th, 2021. So for example, if the landlord files an eviction based on nuisance, even if the tenant wasn't able to pay rent during COVID-19, in the eviction suit, the landlord can't collect those rental damages. Even though the landlord can't ask for rent owed in an eviction case, they can file a separate small claims action, but only on or after August 1st, 2021. If a tenant can show their landlord was actually retaliating for non-payment of rent, so the landlord maybe filed a nuisance case, but what the landlord was really getting at was non-payment of rent, the landlord can be penalized under Civil Code Section 1942.5. There are also increased penalties for illegal lockouts and utility shutoffs. They're actually 10 times what the previous penalties were. Landlords can't apply a tenant's security deposit to COVID-19 rental debt while the tenancy is still in place, unless the tenant agrees in writing. They can apply it, however, once the tenancy ends. Landlords also cannot apply a monthly rental payment to COVID-19 rental debt other than the prospective month's rent, unless the tenant agrees in writing. So for example, if you are paying rent for April, the landlord can't apply that to rent that you may have owed maybe in March of 2020, unless the tenant agrees to that in writing. So what happens if there is remaining debt? Landlords can collect COVID rental debt in small claims court starting August 1st, 2021. For lawsuits that were started prior to SB 91 and were stayed instead of actually moving forward, they can be continued to July 1st, 2021. SB 91 also prohibits the sale or assignment of all COVID rental debts between March 2020 and June 2021. So it prohibits the sale or assignment until July 1st, once SB 91 expires. After July 1st, this prohibition is partially lifted. There are still some restrictions on selling and assigning the debt to third parties. All non-payment evictions filed between March 4th, 2020 and June 30th, 2021 are masked, meaning they're kept confidential, even if the tenant loses. Generally, eviction cases are public, and tenant screening agencies that landlords rely on for background checks have access to eviction-related data. But for non-payment evictions filed during this time period, they should be masked, meaning they should be kept confidential. So now that we've kind of gone through SB 91, let's review the CDC moratorium and protection. So this is a federal protection related to COVID-19. So the CDC moratorium protects tenants for eviction based on non-payment of rent until June 30th, 2021, as long as the tenant provides a declaration stating the following. One, that the tenant used their best efforts to obtain all available government assistance. Two, the tenant earns less than $99,000 in annual income or $198,000 for joint filers. Three, the tenant can't pay full rent due to substantial loss of household income, hours, wages, or extraordinary medical expenses. Four, the tenant is using best efforts to make timely partial payments. And five, eviction would likely make the tenant homeless. Kind of one of the significant differences between the CDC moratorium and the COVID-19 related financial distress declaration under SB 91 is that the CDC moratorium doesn't specify the financial distress has to be related to COVID. It seems to be getting more at the fact that people shouldn't be homeless during a pandemic. And this is what the CDC declaration looks like. There's a section kind of assessing whether the tenant qualifies under the CDC, and the second portion asks the tenant to certify all of the things that we discussed in the previous slide. All right, so now that we've reviewed SB 91 and the CDC moratorium, let's go through a few other tenant rights, laws, and protections. So we'll review some local rules, we'll review AB 1482, and we'll review reasonable accommodation. So first, let's go over the Los Angeles County eviction moratorium. So a quick caveat about the LA County eviction moratorium. Just because you live in LA County doesn't necessarily mean it applies to you. If you actually visit the website, there are a lot of cities that have passed their own eviction moratoriums. So if that's the case for your city, then those are the laws that would apply to you. The LA County moratorium applies to everywhere else. But if the LA County eviction moratorium does apply to you, it's effective from March 4th, 2020 through June 30th, 2021. It prohibits evictions for non-payment of rent due to COVID-19 related financial hardship through September 30th, 2020. And the reason that it's kind of stopped at September 30th is because after that time period, SB 91 protects against non-payment related evictions. It also prohibits evictions for no fault reasons, including but not limited to substantial remodels or demolition of property. It also prohibits evictions for COVID-19 related violations due to unauthorized occupants or pets, nuisance, or denying entry to a landlord. So for example, if you have parents that contracted COVID-19 and they need, and you want to take care of them, you had them move into your unit, the landlord can't evict you based on maybe your parents being unauthorized occupants. That type of eviction is prohibited under the LA County eviction moratorium. And then finally, the LA County eviction moratorium also provides COVID-19 related non-payment protections for commercial residents. So next, let's discuss the LA City eviction moratorium. So if you are in LA City, this eviction moratorium is effective during the local emergency period and for 12 months after its expiration for residential tenants. So as of now, there's no expiration date. We're still in the emergency period. And once the emergency period is over, the moratorium will continue to be effective for 12 months afterwards. Under this moratorium, landlords can't evict a residential tenant for non-payment of rent during the local emergency period if the tenant is unable to pay rent due to circumstances related to COVID-19. Tenants have up to 12 months following the expiration of the local emergency period to repay any rent. The city moratorium also protects commercial tenants during the local emergency period, and instead of 12 months, it's 3 months thereafter. Commercial tenants will have 3 months following the expiration of the local emergency period to repay any rent. And again, remember that other cities in the county have also enacted protections, so check your local government for any other laws that may apply to your specific situation. All right, very quickly, I just want to go over some of the AB 1482 protections. AB 1482 is a statewide bill and includes a rent increase cap and a just cause eviction law. So under AB 1482, if you are protected under AB 1482, rent increases are capped at 5% plus consumer price index. And again, this is also dependent on where you live, or up to 10% total. AB 1482 also requires just cause eviction after 12 months of tenancy. So after a tenant has been leasing for 12 months. This bill also provides for relocation for no fault evictions, and the amount of that relocation is 1 month's rent. And then finally, I wanted to discuss reasonable accommodations. So a reasonable accommodation is a change, exception, or adjustment to a rule, policy, practice, or service that may be necessary for a person with disabilities to have an equal opportunity to use and enjoy their living space. A reasonable accommodation is always available for tenants or unlawful detainer or eviction defendants to request. And there are 3 elements to a reasonable accommodation. The tenant has to have a disability. The accommodation must be necessary due to the disability, and the accommodation does not create an undue burden, fundamental alteration, or direct threat to health and safety. So a reasonable accommodation can look like installing a wheelchair access ramp, or it can even be as simple as if a tenant receives disability insurance, maybe on the 10th of the month, but their rent is due on the 1st of the month, asking the landlord to instead accept their rent on the 10th of the month. So those are a couple examples of what a reasonable accommodation might look like. This is a quick example of a reasonable accommodation letter that we've drafted on behalf of a tenant. It doesn't have to be this long and complicated, so long as you show those 3 things that I mentioned in the previous slide. That's sufficient in requesting a reasonable accommodation. And then to kind of close out the presentation, I wanted to discuss some of the common defenses to eviction. The first is breach of warranty of habitability. The argument here is that the value of the unit does not amount to the rent required. So perhaps the unit violates so many health and safety codes that the amount that the tenant is paying isn't actually equivalent to the value of the property. The next defense is discrimination. So this is when the landlord is seeking to terminate the tenancy because the landlord is acting arbitrarily and is discriminating against the tenant. The landlord may be discriminating on the basis of race, national origin, gender, age, sexual orientation, religion, family status, source of income. Next, the tenant can assert that the landlord has violated a rent control ordinance. So maybe the rent demanded exceeds the legal amount that can be demanded under a rent control ordinance. Next, defective notice. So there are very specific requirements on what needs to be included in a notice. This is the eviction notice, the one that starts off an eviction case. And if the landlord fails to include any of those very specific requirements in the notice, the tenant can say that the notice was defective, and that is a defense to an eviction. Next is waiver. So waiver is when the landlord knew of the tenant's alleged breach, but the landlord continued to accept rent from the tenant for a period of time after the breach, after the notice expired. And then finally, estoppel. So estoppel is when the landlord either agreed with the tenant, maybe orally, maybe written, that the rent demanded in the notice can be paid at a later date. So basically the landlord said something that the tenant relied on and the landlord is now changing his mind. Oh, one more defense, retaliation. So this is when the landlord served the notice and filed the lawsuit after the tenant complained to a governmental agency about the unit. And a couple of examples about this of retaliation are if the landlord demanded that the tenant disclose their immigration status, if the tenant is a victim of domestic violence and the landlord is retaliating on that basis. Victims of domestic violence, there are actually specific housing related protections for domestic violence survivors. So they should bring those up as well. And just a reminder that all of these defenses are going to be alleged in the answer, which is again why it's very important to file an answer within that 5 court date time period. Otherwise, the court will never hear or any of these defenses. These are the defenses that that a tenant would raise in the answer. And then finally, how do I access neighborhood legal services? So the presentation included a lot of information, and what laws apply to you is very dependent on where you're located. So if you have questions about your specific situation, then you should definitely reach out to NLS. To access PEP services in particular, and PEP is the team that I'm on where we address barriers to housing. So to access PEP specific services, you have to be connected to a homeless services provider. So depending on where you're located, you would want to connect to a homeless services provider in your area, and they could then refer you to receive PEP services. So for SPA 1, which is the Antelope Valley, the way to get connected is to walk into or call Valley Oasis. For SPA 2, which is the San Fernando Valley, you would walk into LA Family Housing. And then for SPA 3, which is the San Gabriel Valley, you can call 211 to get connected. And then to access general neighborhood legal services assistance, you can call us at 1-800-433-6251. We also have an online application process at nlsla.org /services/help. For housing specific issues, if you fall outside of our 3 spas, which is Antelope Valley, San Fernando, or San Gabriel, you can also complete a referral at stayhousedla.org/referrals. And I'll leave this slide up for a few moments in case folks want to take down this information. All right, and then this is the final slide. I just wanted to show you what the Neighborhood Legal Services and Stay Housed online applications look like. The one on the left is the NLSLA online application. If you look in that 3rd column, there is a form that you can fill out to apply online. And then on the right-hand side is the Stay Housed LA application. It will basically walk you through, ask you a lot of questions, and eventually refer you to one of the legal aid organizations in LA County that may be able to assist you. All right, thank you very much for joining me, and I will pass it back to Valerie.
Hey, Jumana, do you want to take a second to review some of the general questions our attendees have?
Yeah, absolutely. Someone asked, does all of the moratoriums apply to single family house rental? If it does not, can the landlord evict based on no fault, like moving the family or relatives into the house, or the landlord wants to occupy the house instead? Sam, I would suggest reaching out since this seems like a very specific situation. Generally, under SB 91, it does require just cause. I would have to double check whether what type of no fault reasons are permitted under SB 91, but there may be other moratoriums that apply to your specific situation that may prevent no fault eviction. So someone else asked, what can a tenant do when they were approved for the COVID-19 rent relief program, but the landlord refused to complete and or sign the forms? So Janet, I'm not sure if you're asking specifically about the SB 91 rental relief program. I know there were a few other rent relief, like local programs. As for the SB 91 program, even if the landlord refuses to kind of accept the 80%, forgive the 20%, there is supposed to be a way for the tenant to receive 25% of the rent owed, so that they can still be covered under SB 91. And then I think the final question is about access to the slides. Maybe I can send it out to Paula, who could maybe distribute it to the attendees. And I think that's it. Those are all of the questions.
Hi, Jemana. Apologize. This is Callie May. We received one question from the YouTube stream. It just asked, are the forms printed in multiple languages? The COVID financial distress forms.
So the financial distress forms, I know our office maybe has them in English and Spanish. I'm not sure if we have them in additional languages. They're not specific forms. They're not like a standardized form. If the landlord would basically attach a blank declaration to the notice that they provide you. And they should and I believe that they should, if your lease was negotiated in a different language, then they should provide it to you in the language that it was negotiated in. Okay, I also see a question here for what are the penalties for a landlord who violates any of the provisions of AB 1482 or the CDC and county protections? So AB 1482, I'm actually not sure. I know there are penalties for the CDC protections. I'm just not sure what they are. Maybe, Carolyn, if you are asking about a specific situation, you can reach out and we can let you know what specific penalties you may be entitled to. And I think that's it for questions. I'm not seeing any others.
All right. Then thank you, Jemana, for that wonderful presentation. So on behalf of APALA and NLSLA, thank you for joining us today. We hope this information has been useful to you. If you would like more information about APALA, please visit our website online at apala.org. That's apawla.org. Or email us at apalaevents@gmail.com, and we will reach out to you. Thank you so much for joining us today.